Hello, my name is Sarah Coderre. I'm an employment law, human rights law, and labor law lawyer at Bow River Law in Calgary, Alberta. Today I'm going to be answering the question of how do I negotiate my severance package? So, there are two different approaches that you can use to negotiate a severance package, but whichever approach you choose and whichever one you feel is best in your circumstances, I would strongly recommend that before you begin any negotiations, you sit down and speak with an employment lawyer and you determine what is an appropriate severance package for you in your case. If you are using some of the conventional wisdom that's floating around out there, like 1 month per year of service, if you're a manager, you might be undervaluing what your severance package should be. And so it's very important to speak with an employment lawyer because the facts of your case, who you are as an employee, how long you worked with the company for, how old you are, what was your role? Did you have any direct reports? How senior in management were you? How specialized is your role? How difficult would it be to find another job that's comparable? All those factors have to be taken into account when we're trying to determine what an appropriate severance package is for you, because a severance package is really a payout of the reasonable notice period in your case. That's what you're trying to negotiate with the employer. And the reasonable notice period is really the period of time it's going to take you to bridge the gap from the job you've been terminated from to new employment that you might find in the future that's comparable. So, with that being said, there are two approaches. One I will call the hard approach, and one I will call the soft approach. The soft approach is where the employee, armed with knowledge and information from an employment lawyer, attempts to negotiate a severance package for themselves with their employer directly. This softer approach is oftentimes successful when an employee is somebody in very senior management and the company is relatively small or closely held, such that the employee has a direct personal relationship with the decision makers, with the people who are going to decide how many zeros are going to be at the end of that severance payout check. Um, that soft approach may also be appropriate in a case where it's a smaller industry and somebody wants to preserve their reputation at the end of the day and not create waves or create a lot of potential conflict with this employer because they may in fact end up working with them again, or their paths may cross if this person who's been terminated becomes a consultant and then subsequently has their former employer for a client in the future. The hard approach is where an employee may choose to get an employment lawyer involved right from the beginning in negotiating for them. So, in that case, what usually happens is an employee will come to us with a severance package for review. If we review the package and it is determined that the package is not enough, then we will draft what's called a demand letter to go to the employer to outline not just how much more we think this employee is entitled to, but most importantly, why. The severance negotiation, whether you're taking the soft approach or a hard approach, needs to be rooted in legal reasoning and logic. You cannot just go to an employer and say, I feel like I deserve more because of how loyal I've been to the company. That doesn't hold any weight legally. Instead, what you would need to say is, look, if you're doing the soft approach, I've spoken with an employment lawyer. They've told me based on the case law, I'm entitled to a reasonable notice period of 18 months. You've offered me a severance package of 8 months. I'm prepared to resolve this with you for a severance package of 14 months and compromise a bit on what I'm worth in order to receive something that I think is fair. That would be an approach you could take, for example, with a soft approach if you were negotiating for yourself. But of course, the strength in that position that you would take comes from the fact that you have the legal argument that you're going to present to the employer because you've spoken with a lawyer already. On the hard approach, in the demand letter, we outline all of the law. We provide the employer with case law. We provide a fulsome legal analysis as to all the relevant factors that a court would consider in determining what your reasonable notice period is. And we provide our math and our calculations as to how we get to the numbers that we are calculating for you when it comes to the reasonable notice period. And again, because the reasonable notice period is a period of time it might take you to find a new job, and an employer, if they chose to keep you employed during that period of time until you found a new job instead of packaging you out, They'd have to pay you salary, they'd have to give you benefits, you might be entitled to bonuses or payout of RSUs or something of that nature. All that has to be calculated and determined in order to present them with a severance package counteroffer, essentially. It is important to remember, regardless of whether you take a hard approach or a soft approach to negotiating, that your offer that's being made to the employer, sorry, is a counter offer. So they have made a severance offer to you. You are coming back with another offer to them. That counter offer that you're making technically cancels out their original severance offer. So it's technically not on the table anymore. What I've seen in my experience is that most employers will either take one of two approaches. They'll either come back and say, no, we're not prepared to negotiate, so you take it or leave it in terms of the original severance offer. Or in many cases, because they do want you to sign a release, more often than not, to protect them from being sued by you in the future, they will agree to increase the severance package from what they've originally stated. And it may be at the number that you provided. It may be close to that. It might be a little bit less than that. But that's how you would go ahead and negotiate. When you have a lawyer involved using that hard approach, oftentimes it's going to be in a case where you don't know the decision makers personally, you don't have that personal relationship, or it's with a fairly large corporation that you know they have in-house counsel who's whispering in their ear telling them, oh, no, 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 you need to give them this, or we could push back, or I don't think this is a fair amount. So you do need to have legal counsel in those cases. And in fact, if you have a lawyer at the forefront doing the negotiations for you, depending on your relationship with the company, that can be very advantageous to you because they believe and they see that you are serious about your beliefs and your legal arguments, and that you are willing to take things to the next step if you can't reach a deal with them. Most employers don't want to be sued. They don't want to deal with litigation because it's expensive and it disrupts their business. So most of them do want to reach a deal with you. It's just a matter of how good will that deal be at the end of the day. And whether you take the hard approach or the soft approach to negotiating, going in with appropriate legal knowledge and being able to make those legal arguments, whether through your lawyer or on your own, is going to set you up for success when you're negotiating a severance package with your employer.